them, they can come in front. The chair, who will speak first, will be followed by the official from Kenya Law Reform, Kenya Law Reform Commission, and we have the IEBC officials also, who is the representative of the chair of the IEBC, and he's here with us. So that's going to be Chebukati's voice. Or yeah, at least for this for our purposes. And of course, I'm sure you're going to have intriguing questions. Rift Valley Chair. It's going to be strictly 10 minutes in the interest of time.
For fear of not properly recognizing protocol, let me just say good afternoon. I can see a good number of our guests are yet to come back from lunch, but I hope we can still proceed as directed. We've had some fruitful pointers from the morning discussions, and on behalf of LSK, I'm only here to highlight what perhaps should be or is our role as far as access to democracy, to justice and democracy is concerned. As a law society, we are a statutory body, and as recent as 2014, that body was devolved to 8 branches across the country. And the 8 branches also oversee a number of centers, some of which are also referred to as chapter by virtue of the number of advocates they represent. The theme access to justice with a specialized aspect of electioneering period speaks to what our role as the society is. And our role is particularly defined under the Law Society of Kenya, Act 2014, where we are mandated to assist government and courts in matters relating to legislation, administration of justice, and the practice of law in Kenya. While doing so, we are required to uphold the Constitution and advance the rule of law, so that we're able to protect members of the public in matters touching on the law. And therefore, access to justice is fundamentally what we are supposed to, it's a principal value that we're supposed to really look up to when administering our roles. So I will quickly get into what our roles are as a summary, and this is emanating from whatever discussions we've had in the morning. One of our main roles is legislative drafting. Of course, this is done through the Office of the Attorney General, and it begins with the aspect of policy making. The question is, as many advocates perhaps looking at me would attest to, is how many of us as advocates practicing in our ordinary offices are legitimately involved in these processes of legislative drafting. That would be a question perhaps to be answered by the Kenya Law Reform Commission and the AG by extension. But then what I would wish to confirm is that as a society, the bills which are to be discussed in Parliament are usually sent to us for comments. And again, we are supposed to really give our insights from the perspective of the common and ordinary mwananchi. Because with LSK devolved, it means we oversee a unit that is quickly manageable, and therefore its comments on whatever the laws concerned are usually, we are able to usually get them. The reason why we as a society will still reiterate that this should remain our fundamental role is the manner in which some of these bills or regulations are usually circulated at the last minute. We have seen a lot of bills circulated at the very last minute seeking to amend various positions of electoral laws. And some of these amendments usually result in a chaotic process. And therefore, it still remains our fundamental role so that we are able to reflect within the body of those provisions what the common mwananchi seeks to be addressed. The other role, which is not substantively performed directly by the LSK, but it is done through several bodies, that is through LSK, is the role of civic education. I think it has been recommended here by EU that civic education should be a continuous cycle. It should be a process that should be undertaken from the moment elections are done to when the next elections are undertaken. This will ensure that the public, the common mwananchi, is able to familiarize themselves with the law, is able to confirm the positions that they are supposed to take, and it also informs even the persons they will eventually vote for. IBC, which ordinarily should be undertaking civic education within the election process, is supposed to actually oversee this, and I believe in collaboration with the society, so many advocates should be involved so that whenever interpretation of the laws is called for, then we are able to give the actual insights. As a society, we've also been tasked with observation and validation of the election process. In the recently concluded elections, volunteers now from the bar were they were posted in the several polling stations just to oversee the manner in which the elections were conducted. I'm sure a report on this from our perspective will also enrich this entire discourse. I believe that should also be a discussion to inform whatever policy documents that may emanate out of this conference. We also engage in national dialogues, which is perhaps the most recent and an increasingly popular tool for conflict resolution and political transformation. I think the most prominent national dialogue that anyone would remember is the 2007 election. Although we were also represented by a divided faction, but nevertheless, it was a form of conflict resolution within an electioneering period, and that birthed some form of peace which informed whatever we're currently experiencing. The larger part of our roles is on litigation and dispute resolution. And while we undertake litigation and dispute resolution, we do so as a matter of public interest litigation. In the presidential elections, we made an application before the court which was allowed to participate as amicus curiae. And that basically means a friend of the court. Although I think a good number would still argue that being limited to just providing a brief would not really bring out whatever issues we would have wanted addressed. But nevertheless, those are some of the ways in which the society embraces access to justice and informs the court in a manner of advocating for whatever rights that exist. Currently, again, individual members, not necessarily the law society, represent so many parties with the ongoing election petitions. We had 8 in the Supreme Court. We have 12 gubernatorial elections around the country, and 2 on the senatorial positions, 4 election petitions where they're contesting the women rep positions. We have 28 contesting the positions at the National Assembly, and we have 77 contested election petitions for the County Assembly. What do all these litigation result in? Whatever decision that comes out of each petition substantively informs the legislative and policy amendments, which is also the fulcrum of this discussion. I believe, therefore, based on what had been highlighted previously, the focus should be on how advocates actually contribute through research or through these several fronts, the development of our electoral laws, so that ultimately whenever elections or in future whenever elections will be held, we will have the sense of acceptance. And on this, I particularly want to perhaps pose a challenge to all of us on looking into whether limitations on when, we already have limitations on when these cases should be decided, but do we need to discuss an issue about the issues that the court need to address at particular stages, so that we do not end up, for instance, crowding the Supreme Court with a petition where they are supposed to decide on so many issues arising out of a petition. This is what I mean. Since the election is a process, it is a cycle, do we need to discuss a situation where whenever pre-qualification for firms who will print the ballot papers is floated, do we need to discuss a situation where any issues arising out of this pre-qualification is addressed as a preliminary issue before we get into the elections? We already have ways of addressing the nomination processes of candidates, that is by the respective parties, but is it sufficient enough so that as and when it is concluded, by the time we get to the elections, the only issues the court will be dealing with is numbers? In my opinion, this forms a vital discussion, so that whatever ends up in court, we do not have a situation where we question the timelines within which the court may have decided on an issue, so that we have to attribute it to the length of time that has been given. For instance, the Supreme Court, which had to decide on 9 critical issues, one which would have really left an impasse, that is on the quorum of the IEBC, that is the commissioners in the IEBC, and the manner in which they are supposed to transact. The law as it is, that is under the IEBC Acts, says that the chairperson must be an advocate who is capable of being a judge. If you were to look at the other commissioners, none of them would have fit that qualification, so that were the court to decide that the chairman was culpable of the offenses that were alleged, would we have, in essence, proceeded with an election subsequent? So these are just some of the informative areas that we would wish to have as a matter of discussions within this entire conference. Otherwise, thank you for this invitation, so that we are able to present and let known our roles, which may appear simple, but when magnified, has an impact on the entire process. Thank you.
Thank you so much, Chair LSK Rift Valley, for that broad roadmap and overview of the role of the Law Society of Kenya in these electoral disputes and on the question of access to justice. The next speaker is the representative from the Kenya Law Reform, the Chair, Kenya Law Reform Commission.
Good afternoon, everyone. The trouble with speaking in the afternoon is you're in the graveyard shift, and the chances that you might be speaking to yourself are very, very high. And that's not a bad thing, because it means that I can get away with a lot. Nobody will hold me to it. But let me start off first by thanking the University of Egerton for inviting me to share my perspectives at this conference. And let me mention how I'm particularly proud to be associated with the Faculty of Law at the Egerton University, particularly because I was a member of the Council of Legal Education and the Committee of Quality Assurance and Compliance, which undertook the inspection of the university's Faculty of Law, I think some 7 years ago. So I'm very proud that the university was then subsequently accredited as a legal education provider. So I feel like I'm watching a baby, come into its toddler phase, not toddler phase. This is, if you're in CBC, you'd be in grade 1. Yes, I think that's, so let me thank Dean Dr. Ruth Ora very much for this invitation. And I think it's very commendable that you, at the Faculty of Law, you've developed Follap and the niche that you have of using legal aid to promote access to justice amongst vulnerable members of the community. I do recall that this was one of the areas you pitched very strongly during the accreditation process, and I'm happy to see that this did come to fruition. So the theme of the conference is access to justice during electioneering period in Africa in the 21st century. And our facilitator in the morning asked us what our definitions of democracy was. I know that access to justice, democracy are ideals that are very close to our hearts, and many of you here are experts in those areas. I'm like Professor Patricia Mbote. I will not claim to be an expert in matters election and democracy. But like any good lawyer, I always make sure that I have a clear understanding in my mind of topics that I'm asked to speak to. And as lawyers, we use words very judiciously and very advisedly. And in the field that I'm in, where we work on reforming of law and drafting of legislative proposals, we must make sure that words we use are well understood, and there's no doubt about it. So I thought that maybe as I focus on the theme of access to justice and democracy, I will explore some definitions, but at the end of the day, my remarks will be to reflect on what access to justice is and the process of the reform of electoral laws. And I think we'll also look very quickly at the legislative and institutional framework for access to justice in relation to election-related disputes. And I think this is what we are all generally calling electoral justice. And from my vantage point as chair of the Kenya Law Reform Commission, I think it is very important that we look at areas where the framework is working, but we also point out areas where there might be gaps, areas where there are challenges, and to identify areas for law reform. And I think already in the discussions that have happened in the morning, some of these have been flagged. So, access to justice, do we have a common understanding of this? I know the Constitution is very clear when it says that in Article 48, that the state shall ensure access to justice for all people, for all persons. But do we have an agreed definition for this? And I'd like to borrow the definition that was provided by the court in the Kenyan case of Dry Associates Limited and Capital Authorities, which said that access to justice included access to dispute resolution mechanisms that are accessible, affordable, procedurally friendly, as well as access to information and legal representation. So access to justice therefore includes the right of every individual to have their grievance heard and determined on the merits by an independent judiciary. But to have meaningful access to justice, citizens must also be aware of their rights as enshrined in various laws, and also to understand how the legal system works. So that's my working definition for access to justice. We were asked what our definitions for democracy is. And I think a couple of people in the morning used the one that we all know, democracy being government of the people, by the people, for the people, which I learned when I was 6 years old, I think, or something like that. And you know, it's only recently that I found out that this was a definition coined by the 16th President of the United States of America, Abraham Lincoln. I just assumed it was our definition as Kenyans. Yeah? But the Oxford English Dictionary defines democracy as a form of government in which power resides in the people and is exercised by them either directly or by means of elected representative. And this is a concept that we have definitely embraced in the Constitution that was promulgated in 2010. And Professor Mushi of the University of Dar es Salaam captures the essence of modern liberal democracy when he observes that it refers to a political system in which representation, participation, and accountability are realized through regular competitive elections under conditions of civil and political liberty guaranteed by the rule of law. Let me just move a little further and talk about, and note that the World Bank has observed that democracy and the rule of law prevail where government itself is bound by law, where everyone in society is treated equally under the law, where the human dignity of every individual is recognized and protected by law, and where justice is accessible to law. So clearly, access to justice is a basic tenet of the broader principle of rule of law, which we know is guaranteed in our supreme law. And our, I'll call it our economic blueprint, Kenya's Vision 2030, recognizes that without access to justice for the majority of people, then the rule of law cannot be gainsaid. So I think from these definitions, we can see that there is a very close relationship between the rule of law, access to justice, and electoral justice in particular. And I think we've seen that the right to access to justice encompasses different components, and what we should be able to establish is whether these are contained in our legal frameworks. So when we speak about access to justice in electoral processes or access to electoral justice, we can only fully appreciate this if we recognize that political rights and guarantees are human rights, whose violation calls for effective redress through due process and the right to a fair and public hearing. And you know our political rights are guaranteed in Article 38 of the Constitution, and these include the right to form, participate in political parties, participate in activities of a political party, free and fair elections, be registered as a voter, and be a candidate for public office or office within a political party. These are enshrined in our Constitution. So in discussing the right to access to electoral justice, we need to be able to assess whether the existing legal framework on the electoral system includes certain key salient features which guarantee access to electoral justice. And let me just highlight the following. So the right of access to electoral justice mechanisms for all players on equal footing, regardless of the type of grievance that is alleged, the independence of the electoral justice bodies, or those bodies that have set up electoral dispute resolution mechanisms, and we know which those are. Access, of course, to those institutions, and I think for a long time we were focused about people being able to physically access courts and institutions. With the coming of COVID, I don't know that we still talk about access to physical locations. There are other issues, whether you can actually access the possibilities that have been created by, accessing courts online, etc. But that includes the whole issue of affordability and costs and the time required to access them. And as I'm raising all these issues, think about it in the context of electoral justice. If you are the person who's seeking electoral justice, these are things that should still be of concern. So due process, of course, is one of those salient features, that the right to a fair hearing is safeguarded. There's one salient feature of an effective legal framework is one that it incorporates alternative conflict resolution mechanisms, and I think we know that our Constitution does that. And then the requirement that the arbitrating body gives a reasoning behind the judgment. I put this together with the help of colleagues. I will not tell you where they are drawn from, but I think they pretty much spell out very important salient features that we can keep in mind as we reflect on whether our existing legal system or existing legal framework on electoral, the electoral processes or cycles can guarantee access to electoral justice. And I think we should also ask ourselves whether the legal framework guarantees the protection of other fundamental rights and freedoms, including the freedom of expression, freedom of association, assembly, gender equality, security, and the right to information. Now, the reason why I choose to focus on the electoral laws and the process of reforming electoral laws is because of the institution that I represent, the Law Reform Commission. And so just allow me to highlight the role of the Law Reform Commission, which has played its part in the reform of electoral laws and those relating to the access to electoral justice. The Law Reform Commission's mandate, as spelled out in our Act, Section 6 of the Act, is to keep under review all laws of Kenya and recommend reform of the law by ensuring that the law conforms with the letter and spirit of the Constitution, that the law is systematically developed in compliance with values and principles enshrined in the Constitution, that the law is consistent, harmonized, simple, accessible, modern, and cost-effective in application. We also have the responsibility for keeping the public informed of reviews or proposed reviews of any law. And this is very critical when we consider that public participation is very, very important. And when Learned Counsel said that interested in ensuring that advocates, and not just advocates, all citizens play a role in the reform of laws, we have a responsibility to make sure that you do play a part in that role. And we also undertake public education. I've just highlighted functions that I think are very critical in this regard. So over the years, the Kenya Law Reform Commission has partnered with various institutions in the development of Kenya's legal framework on electoral justice. We've worked with the defunct Commission on the Implementation of the Constitution when in the first 5 years there was a lot of work being done in ensuring that the laws that were set out that had to be enacted in 5 years were done. We worked with the Office of the Attorney General, the IBC, the Registrar of Political Parties, the Judiciary, and the Political Parties Disputes Tribunal. But I think we must observe that with the promulgation of the Constitution of Kenya, there have been various statutory reforms that followed towards implementing the Constitution, And these have included efforts to seek to comprehensively reform the electoral framework and to enhance access to justice and protect certain fundamental rights and freedoms. And the present legislative framework has established a framework that supports electoral justice. It has established key actors that provide mechanisms to resolve electoral disputes and sets out these mechanisms very, very clearly. Let me just mention here, and I think you'll agree with me, that it's a commonly held view that it's because of ineffective mechanisms for access to justice in the 2007 elections that we saw the kind of post-election violence that we saw. And indeed, Justice Mutunga, in a Supreme Court decision in 2014, describes the history of democracy and electoral justice. And for those who may not be aware of that journey, he pointed out that Kenya's political history has been characterized by large-scale electoral injustice through acts of political zoning, privatization of political parties, manipulation of electoral returns, perpetration of political violence, commercialization of electoral processes, highly compromised and incompetent electoral officials, and a host of other scenarios. That is what characterized the country's electoral experience and made our democracy, not as refined as it should be. And I think the question we should ask ourselves is, fast forward to 2022, whether our legal framework has addressed those issues that were of concern in 2007. I think we've taken note as a country that an election is not a single event. The election day is an event, but the electoral process is a continuous process spanning from when the electoral management body is set up, to party nominations, to the campaign period, through to the election date, and announcement of results, and subsequent resolution of electoral disputes. I think you will agree with me that many pre-election disputes are about people feeling that their political rights have been breached. And remember, we pointed out what those political rights are. To address those concerns, to address the grievances that citizens have when they feel that there's a breach of their political rights, various judicial and administrative election dispute resolution mechanisms have been established to deal with those conflicts and those disputes. I think the question that was asked in the morning, and we'll keep having to interrogate this, is whether those mechanisms are credible, effective, and efficient, especially, before the elections, the pre-election disputes. But we also know that the court has jurisdiction to listen to pre-election disputes, but it shares this with other electoral dispute mechanisms established under the Constitution. So to just give an overview of the provisions in the resulting legislative framework that we've talked about, we can confidently say that post the 2010 Constitution, there are various provisions that guarantee access to electoral justice. I'm reluctant to go through them. As any good lawyer, I have pages of actual provisions. I don't think I need to go through them, except to highlight that The constitutional provisions are found in Article 47, 48, Article 1592 of the Constitution. Honorable Ocheng in the morning walked us through a number of laws that have been passed by Parliament towards, in line with their mandate to set up mechanisms for the timely settling of electoral disputes. We know that IEBC has a mandate under its act to settle electoral disputes relating to the process of nominations. And I think for the first time in my voting history, I actually paid attention to the fact that IEBC actually has that role. I don't know how many of you realize that. Pre-election disputes include disputes within political parties, electoral offenses, voter registration disputes, among other things. I think under the Political Parties Act, there's also a mechanism that relates to settling of disputes concerning the regulation, funding, and registration of political parties. The Election Offences Act creates a raft of offences. The Elections Act, interestingly, of 2010 creates, envisages that the IEBC will set up peace committees that uses mediation to manage disputes between political parties. I wonder whether that would have been something that has actually been put in operation. And I think we heard about the Election Campaigning Financing Act, which in itself also has a dispute resolution mechanism, giving IEBC the power to investigate the breach of this act. So we've noted that various institutions are mandated to put into operation certain electoral dispute resolution mechanisms, and that's why we probably are able to say that we do have a robust election dispute resolution framework in our laws. Let me move then to just speak about to challenge us to ask ourselves this question, having noted the legislative and institutional framework for electoral justice. We should, as actors in this space, continuously assess whether there are barriers to the access to electoral justice. Are the laws actually adequate? Are the laws being fully implemented? Are they cumbersome? Are they too expensive to implement? Do they create barriers, of the kind that we talked about? Is the actual process of seeking access to electoral justice unaffordable, expensive? Are there gaps in the law that should be addressed? And it's very interesting that, and I think Lynn, is she Lynn from the EU, reflected on the report from the EU Election Observer Mission. I think if we analyze the various reports from the observer missions of the recently concluded election, we can extract challenges that have been identified and the recommendations that have been made with regard to possible reform of our electoral laws with a view to strengthening our democratic processes and ensuring access to electoral justice. I have not done a deep dive into this. As Patricia said, these discussions haven't happened yet. I think Follap is actually providing a first forum for these discussions to happen. But the AU COMESA Election Observer Mission highlighted in its report that it assessed the legal framework governing Kenya's elections as adequate for conducting credible and democratic elections. And it noted that the framework enshrined, amongst other things, national electoral dispute mechanisms. The mission, however, did point out that last-minute electoral litigations, court decisions, and court decisions sometimes necessitated changes in the election process, and this posed a risk to the smooth implementation of electoral processes. The EU observer mission issues and challenges, I think, were well articulated by Lynn. I'm not going to go into them again. But let me also point out that the Election Observation Group, ELOG, in its statement, because they haven't released their report, but in its statement on the 2010 presidential results, noted that there had been insufficient access to key election information in the pre-election period, and this created challenges around transparency and the ability of stakeholders to mobilize in a timely manner. Remember, in the definition of access to justice is the whole issue of access to information, people understanding the electoral system, etc. So these are some of the issues that we should pay attention to when we ask ourselves whether there are barriers to the access to electoral justice. So whereas there's a general feeling that the framework, the legal framework relating to access to electoral justice in relation to seeking justice in election-related disputes, that this is adequate, there is, however, the view that there's still much more to be done, both by Parliament, and again, Honorable Ochieng mentioned this, by the Office of the Attorney General and the institution that I represent, the Kenya Law Reform Commission, especially as we discharge our mandate of keeping law under review. We ourselves have identified some gaps and challenges in the existing legal framework that still needs to be given attention. The first is the issue of the referendum bill, which still hasn't been enacted. So this needs to be given attention. I think several speakers have spoken to the constitutional requirement for a law on the principle, on the two-thirds gender principle. It's something we are all familiar with, and a lot of work has gone into that, but it still needs, to be dealt with. And again, an issue that Honorable Ochieng mentioned, which we also picked up, is the fact that amendments to electoral laws tend to happen on the eve of the elections, within 3 months, 4 months, which of course complicates the electioneering process. And remember, we are reflecting on access to justice and democracy, access to justice in the electioneering process. And I think there's a concern that whereas we might have a framework that looks very, very good, there may be real issues around implementation challenges. There may be areas where the full and efficient implementation of particular laws remains unattainable. But my challenge to all of us is that it's our responsibility to flag these and come up with solutions to deal with that. Okay, I can see I'm being asked to wind up. I think I can safely say that as the Kenya Law Reform Commission, on our part, we'll continue working with the IEBC and other stakeholders in developing and reviewing laws relating to the electoral process. IEBC itself has set out a raft of reforms that it would have wanted dealt with. But let me also throw these other challenges to the participants at this conference. I hold the view that the responsibility for entrenching laws, policies, and practices that build confidence in Kenyans that there is access to justice and that democratic rights are guaranteed. This responsibility is a collective responsibility. It's not just a responsibility for duty bearers, as state agencies are called, but it's also a responsibility for CSOs and other organizations that have oversight roles, for you to be able to demand accountability, openness, and transparency. And I think we must continue to collaborate in identifying and highlighting issues that are barriers and that impede access to justice. And it is my hope, it's my expectation, that from our various vantage points during this conference, you will keep sharp focus on those responsibilities and the goal of ensuring fairness and justice to the citizen. My reflections when I've been thinking about this topic is that the need for timely reform is very, very important. Of course, that is often a function of political will, a function of having budgetary support to do so, but as the Kenya Law Reform Commission, we understand that this is a role that we should support and to ensure that reform of these processes are done in a timely way. I also see opportunities for collaboration with other actors in this space, especially around providing legal information as we spearhead reforms and implement various laws. There's need to educate citizens about the rights. There's need to educate the public on new laws as they are enacted so that they can effectively, take advantage of these things. So let me conclude finally by quoting, and I shouldn't be quoting US Supreme Court judges, I should be quoting our own judges, but forgive me in this instance. Equal justice under the law is perhaps the most inspiring ideal of our society. It is one of those ends for which our entire legal system exists. It's fundamental, and justice should be the same in substance and availability without regard to economic status. I thank you for your kind attention, and I'm looking forward to the deliberations, the rest of the deliberations during this conference. Thank you.
Thank you so much, Madam Chair, for that wonderful presentation, lengthy and comprehensive, in defiance of the time restrictions, of course. The next speaker is Crispin Owiye, who's going to give us perspectives from the IEBC. And he says he speaks the voice of the chair. I would also encourage him to observe time, 10 minutes at most.
Thank you, moderator. I've negotiated for 15 minutes. All protocol observed. I know the eminent legal minds here. I see Professor Lumumba, Dr. Aura, I see Dr. Orago, and many others. Allow me to leave it at that, appreciating my audience. My name is Crispin Owiye. I head the legal directorate at IEBC. I know it's not pleasurable to a cross-section of Kenyans to mention IEBC. This is because of the work that IEBC does. It is the work of a referee, and in that match, there is always a winner and a loser. In elections, there is no number two, because there is no award for the number two. But this is a constitutional commission established by our Constitution and given a statutory anchor by an Act of Parliament as an independent commission that is responsible for conducting or supervising elections and referenda in this country. The IEBC is established under the provisions of Article 88(1) of the Constitution, and the general mandate is summarized in 11 points, 11 broad mandates that the Commission has. The Commission has a mandate to conduct elections. And these are elections into the 6 constitutionally established elective state offices. It also registers candidates for those elections. And after registering candidates, there are usually disputes that arise from the registration of candidates. So the IEBC has a mandate to resolve pre-election disputes relating to the registration of candidates. The IEBC is also responsible under the Constitution for the delimitation of constituencies and wards. And in delimiting constituencies, it has no mandate to either increase or reduce the number of constituencies, because this is prescribed in the Constitution at 290. So it can only delimit the constituencies in terms of name and in terms of the boundaries. But for the wards, the IEBC has a mandate to delimit in terms of name, in terms of the boundaries, size, and also in terms of the numbers. Currently, we have 1,450 wards. So the Commission, having already commenced the process of delimitation at the preparatory stage, may have occasion to either reduce or increase the number of wards in this country. The IEBC is also responsible for the monitoring and evaluation of elections. And as I will be talking about the election cycle, I'll be mentioning the post-election evaluation stage, under which the Commission evaluates itself by having both a front and a side mirror, doing a self-introspection to assess its missed steps, challenges that it encountered, and then providing a way forward on possible amends to those challenges or hiccups. The Commission also has a mandate to undertake voter education. And voter education is different from civic education. Civic education is broad-based. Voter education is restricted to the electoral process and majorly the polling day activities. So the Constitution limits the Commission to undertake only voter education. But the Commission has power to accredit, which it does, civic bodies to undertake civic education. And by and large, it supports those bodies. The Commission has another mandate, still on dispute resolution, but on the side of enforcement, and that is the enforcement of the Electoral Code of Conduct. Under the provisions of Article 88, 4J, the Commission has authority to develop a code of conduct for candidates and for political parties participating in elections. And in the same Constitution, Article 84, places a responsibility on those candidates and on those political parties participating in an election to adhere to that code. Later on, we'll be looking at the fate of the code, where we are in terms of enforcing the code. Is it a success story or is it a failed project? Now, elections is not an event, but a process. And in looking at the concept elections, we have developed as a country what is called the election cycle. This cycle is continuous and is unending. So you cannot say that now elections has come to an end, and then we take a period, a lull, and then now begin to engage in elections. The election cycle is divided into 3 phases. So we have the first phase, and that is the pre-election period. The pre-election period is a preparatory period. The Commission develops a strategic plan. It develops an election operation plan. It develops guidelines that inform the conduct of a free and fair election. And once it has done that, then the election period onsets. And the election period onsets with the publication of a notice of the general election. In the year 2022, the election period commenced on the 19th of January 2022, when the Commission chairperson published in a Gazette notice the general election date for the 6 elective positions. So now that is the election period. And during that period, we have many activities. We have audit of the register taking place. We have certification of the register. We have registration of candidates for election. We have enforcement of the Electoral Code of Conduct. We have trainings that take place for IEBC staff, both permanent and temporary. We also have capacity building of political parties and independent candidates. Then elections is conducted, and after the elections, we have the post-election evaluation period, and that is the third phase of the elections. In terms of access to justice, what is it that is available to us in the electoral process? What is available is we have provisions for dispute resolution in respect to elections, beginning at the party level, political party level. When the political parties conduct their nominations, disputes abound. So the political parties by law, under the elections, party primaries and party list regulations of 2017, are required to have in place a dispute resolution committee that will address any complaints arising from the process of nominations, or what is popularly referred to as party primaries. The persons who appear before those political party dispute resolution committees have an opportunity to appeal those decisions in the event they are dissatisfied. And that they do in our courts. The establishment of the political parties disputes tribunal, specifically for purposes of addressing grievances between members of political parties and their political parties, is an initiative that came in handy to address complaints of persons who are dissatisfied with the decisions of the political parties' dispute resolution committees. Again, if dissatisfied with the decision of the PPDT, a party has a right to move to the High Court under a judicial review mechanism. At the IEBC level, we have 3 committees that are mandated to resolve disputes. The first committee is the IEBC Registration of Candidates Dispute Resolution Committee. In the year 2017, this committee had a total of 351 cases or complaints. And in the year 2022, we had 324 complaints, quite a small drop. But there are also other disputes that this IEBC Dispute Resolution Committee hears and determines. These are disputes arising from party list nominations. In our Constitution, there is a provision for election of persons to occupy elective positions through the party list framework. They do not go for direct election. And these are the people that we popularly call nominated persons. They are at the county assembly, they are at the National Assembly, and they are at the Senate. And the law provides for the numbers at the Senate and National Assembly. But for the county assemblies, the numbers vary. We have the gender top-up category, we have the marginalized category. And there's a formula that then puts persons who qualify into those elective positions. So those party list matters, but relating strictly to complaints on want of statutory compliance. If it is a complaint between a nominee a hopeful nominee and his political party, then that dispute goes to the political party's disputes tribunal. If it is a question of non-compliance with a statutory provision on party list allocation, then that dispute comes to IEBC. We also have still on access to justice, we have the Leadership and Integrity Vetting Committee of IEBC. This is the committee that seeks to enforce the provisions of Chapter 6 of the Constitution on moral, ethical, and educational requirements. This committee did quite well in the year 2017, but when it came to 2022, there was a setback. The High Court declared that the Commission had or has no business under the Constitution and under the Leadership and Integrity Act to enforce Chapter 6 by setting up a committee to hear complaints on breach of Chapter 6. And it said that in terms of the Leadership and Integrity Act, it is only the Ethics and Anti-Corruption Commission that has a mandate to enforce Chapter 6. And that is how the IEBC's effort to enforce Chapter 6 became a cropper in 2022. Closely related to that is the enforcement of the Electoral Code of Conduct. In the year 2017, the Commission had a total of 71 cases or complaints on breach of the code and imposed very hefty and punitive fines, running into millions, and that served as a deterrent to persons who are keen on breaching the code. Come 2022, the Commission, in earnest, upon publication of the election period or the general election date, summoned 2 sitting members of the National Assembly who, in its view, acted in breach of the code, and that was in March. That was the countywoman member to the National Assembly, Murang'a County, and the member of National Assembly, Gatundu South, then. Before the hearing could proceed, they obtained orders of stay in the High Court through a constitutional petition, and the High Court determined the petition and declared the IEBC Electoral Code of Conduct Enforcement Committee unconstitutional. This is a committee that is established under the Elections Act, the 2nd schedule, and it has its constitutional anchor under Article 88(4)J that gives the Commission the power to develop a code. It is through this committee that the Commission enforces the Electoral Code of Conduct. We appealed the decision to the Court of Appeal. Unfortunately, the Court of Appeal affirmed the decision of the High Court. The two courts said that on enforcement of the code, the IEBC can only investigate, compile a case file, and then forward that file to the office of the Director of Public Prosecution to then enforce the code. But how do you investigate if you have no power to issue summons? Because the High Court also declared that the Commission under the Constitution has no power to issue summons. Do you investigate by issuing a love letter? Certainly not. You can only command the appearance of a person before you as an investigator through summons. So while the power to issue summons has been declared to be unconstitutional, the Commission cannot enforce the code. So that's where we are, and that's why there was an escalation of breach of the Electoral Code of Conduct during the campaigns. The Commission has peace committees. The chair of Law Reform Commission mentioned the peace committees. These committees are found in the second schedule of the Elections Act under the Electoral Code of Conduct enforcement framework. It is chaired by returning officers at the constituency level, but their role is limited to mediation and conciliation. They cannot issue deterrent sentences, or they cannot mete out sentences the way that the Electoral Code of Conduct Enforcement Committee can, in terms of issuance of fines, debarment from proceeding with campaigns, or disqualification of a candidate. Allow me to go to the subject of technology, which is a very sticky but exciting concept in our elections. Is our elections electronic? Is our elections manual? Do we have a hybrid, a mix of both manual and electronic? Those are the questions that I wish to pose. I want to suggest that our elections is manual, because when you go to a polling center or to a polling station, the manner in which you cast your vote is manual. You do not press a gadget, a technology equipment to cast your vote. Electronic voting means using a technological appliance or equipment to cast your vote. The technology that we deploy in our elections is a facilitative media. It is for purposes of, it aids in registration. It also helps you at the polling station to be identified. And then it is also used for purposes of transmission. But we all know that both the Court of Appeal and the Supreme Court have decreed that elections is final at the polling station, and the results of an election are manifested in a physical, original form. For purposes of the presidential election, Form 34A. The physical form is the result, not the transmitted media or form. And that is why the returning officer for the presidential election has to wait for all returning officers from the 290 constituencies in Kenya and one constituency in diaspora, that is 291, be seized of the physical forms, have the forms verified and then tallying is done, and then results are declared. The result is in the original form. And that's why at the Supreme Court, there was insistence by the judges that the physical forms must be deposited with the Supreme Court. Of course, it is law, within 48 hours upon the filing of an election petition. It is law. It is law because they want to have a look at the physical copies, certified copies, and not to over-rely on what has been transmitted. What has been transmitted merely augments. And that's why in Kenya it's very easy to win a presidential election petition if there are grounds based on the result. You only need to have the physical result form, and because all political parties and independent candidates have agents at the polling station and are entitled to a copy of that form, the original form, before the presiding officer takes it to the constituency returning officer. Get you a copy there, or take a photo of it. So that is evidence number one. Evidence number two is what the presiding officer has transmitted to the public portal, which can be accessed by everyone. Transmitted in the presence of the agents. Print it out. That is evidence number two. Have your agent at Bomas of Kenya, when the returning officer appears with the original Form 34S, photocopiers are placed ordinarily at the auditorium. Copies are made in full glare of cameras. Have your copy. That is evidence number three. And just tell the Supreme Court there is inconsistency in these three. You will have one. That's simple. Not Jose Camargo. As I finish, I know I've exceeded my time allocation. I want to talk about IBC as an institution. The employment of commissioners, 6 commissioners and 1 chair. The timing, the law, the selection panel. Right now, 3 vacancies have been declared, and a selection panel is about to be constituted. The LSK, I think, are in the process of interviewing applicants who want to represent the LSK in the selection panel. We have a provision for 4 nominees nominated by the Parliamentary Service Commission to the selection panel. So 4 out of 7. That means that in a way, and there is no provision or no procedure through which the Parliamentary Service Commission nominates these 4. They do not put up an advert. They just agree and propose. And that's what they did in 2017. That's what they did last year when they were employing the 4 commissioners. So 4 out of 7. Nominees unilaterally appointed. That means, therefore, that the Parliamentary Service Commission has control over the recruitment of commissioners. The same parliament has the power to vet the successful candidates. So the High Court, in constitutional petition number 364 of 2020, Omtata Okoit versus the Attorney General, the Law Society of Kenya, and the Parliamentary Service Commission, declared that provision of the IBC Act unconstitutional. So where are we? So I've seen an amendment, a proposed amendment to the IBC Act in the social media. I think it has originated from the Leader of Majority's office, reducing the number of Parliamentary Service Commission nominees from 4 to 2. Does that cure the constitutional infringement that the High Court mentioned? The High Court said the Parliamentary Service Commission and Parliament has no business recruiting. It has business in vetting the nominees. So we are likely to face litigation very soon. That will interfere with the recruitment of the 3 new commissioners and chair. Therefore, I am told there are 9 petitions before Parliament seeking their removal from office. Yet, the process of boundaries delimitation has only 1 year and 3 months to go, because by law, delimitation should take place not less than 8 years and not more than 12 years. The last delimitation was finalized in March 2012. So March 2024, if there is no delimitation, that is an affront to the Constitution. There will be non-compliance with the constitutional requirement for delimitation within that period, and there will be a crisis of sort. Allow me to end by saying that working for IBC is a tough call. It's a tough call. It is risky. It is detrimental to one's career progression. It also interferes with your mental faculties. I have been through that, and I can confess that it is not easy. The 2017 general election was a good election. The 2022 general election was a bad election in terms of its effect on commission staff. And I can confirm to you that the senior management at IBC, most managers, our level directors, even the CEO, everyone is saying, not again. What we went through at Bomas was a terrible experience. An auditorium that has a capacity of about 800, packed with about 200 police officers who are just watching and not doing anything to protect life and property. I know the police have a responsibility, because I've been one, to protect life and property. So as an election official, you are assaulted as the police watch. Isn't that a bad job? But it must be done. We wish to encourage other Kenyans at the right time to take the challenge. Thank you very much. God bless. Asanteni.
In the interest of time, it's now time to invite questions and comments. Who will walk around with the mic? Do you have another mic? Oh, one more. Oh, she wasn't here. So, endless, yeah. National Legal Aid Services. Karibu.
Good afternoon. With all protocol observed, I'm here to make a very short presentation. This is not because I have little to say, but a lot has been said which I ascribe to, and I want to share a little of what I had brought with me, and I'm here the whole week, and I hope to continue sharing the experience that we have in access to justice. At the National Legal Aid Service, we have interacted with most of you. A number of you know where we have come from, and a number of you have been with us in our activities, and we have also attended a number of your activities, and we are happy to continue joining in activities that is access to justice. When we look behind where we have come from, legal aid has gone a long way. I do know and I agree we still have much more to do, and we are here as the service to learn much more from you, improve on what we are doing, and render the services to particularly the indigent persons. We started rendering these services way back in 2008 when we were piloting in only a few areas. This we were able to do because of the partnership that we had. We continue to embrace this partnership because it is what gives us the strength and to expand the numbers that we have in rendering this service. Now, this conference, the discussion on access to justice during electioneering period, it's a conference that gives us an opportunity to relook at access to justice and ask ourselves, how else can we do it to make it better, not just for us and all of us. In electoral process, the speakers before me have mentioned, there are the three stages. There's the pre-election, there's the election process, and there's the post-election. Each and every one of us has a duty to play. At NLAS, we take the role of legal literacy. This is through civic education. We played a huge role in 2010 when we joined other organizations for civic education. Literally all departments were rendering these services to the public. We were spread all over to render services to the public, to create civic education in 2010. We continue to do this by empowering legal aid providers or those in authority who can then help in providing this civic education. We partner with the chiefs, the groups, Nyumba Kumi, the county commissioners. These are our key partners in providing services to wananchi. Then at NLAS, capacity building. The chiefs we work with, the CSOs we work with, and various organizations that we work with. We want to see these people empowered in order to play their role in rendering services to Wanjiko. We do a lot of legal awareness. This we have been able to do by, again, partnership. Partnership is the way to go. Being here to see what Follap is doing and support what Follap is doing gives us more strength in creating awareness and making this society a better place to be. We have, to a large extent, set a higher level for ourselves within the region. We are the talk of the region when it comes to access to justice. We also are at the talk of the region even on the globe when it comes to election matters, considering the manner in which we have conducted ourselves in the past elections. And to enhance these services that we are rendering, it is only through partnership. The EU has come in to give us support, which is creating strength within us. We do have support from government, but no one here will admit that what they have is enough for the activities that they want to render. But one thing for sure, yes, we do get the funding from government, and the partnership that we do takes us a long way in us providing these services. Another way of us playing our role as the service is having the mixed model of rendering our services. The AJS, ADR, those are areas that we enforce a lot in our services, and we are playing our role in reducing backlog in the judiciary, or even stopping some matters going further to the court. As Professor Mbote had said, we play our role in order to reduce matters that may go to court. And as we do that, many a times it's been said that the advocates may not have a job. I look at it a little different. They do have a job by looking at the different way of bringing justice to the citizen. And that is how we ought to go. Research has shown that a number of cases actually do not end up in court. But that does not mean there is justice in the way they ended. It's just that either one decided to forget about it, or there are those who have settled it in a different way other than going to court. The support that we have from EU, it is one of those that you'd say, yes, we are moving places. The best way to improve this is by being true to what it is that we are expected to be. The reports that we get, the information that we share, really puts us in a position where we feel we really need to continue doing this more and more. It is not always correct to say that we need to do things in a specific manner. We are living in an environment that is forever changing. Accommodating these changes is what will actually bring us forth to where we want to be. So today, we have shared a lot. I can see your faces, and I do respect the messages that your bodies are giving you. I do not want to talk much more, but I do hope to get an opportunity to interact with you in the remaining days for us to continue sharing the experiences we have had so that we leave this place more enriched. And with those few words, I say thank you for the opportunity, and I look forward to working with you again.
Question time and comments. Keep it short and simple.
My good friend, Mr. Wee, I know what you go through. There are a raft of proposals for amendment. And my question is not original to me, that a friend of mine once said, is that in Kenya we have the assumption that political bad manners can be resolved through legislation. What is your view on that? That we are just a mannerless group of individuals, the laws are there, and we think the more we amend, the better it becomes. Thank you.
Say your name.
Chimwemwe Mangen, the team leader for PLEAD, which is supporting National Liquid Service. I think I just want to relate with one of the presentation on the what happens during campaigns, during election period, while people maybe in regard to the drought, the food shortage. If we go into the community and ask them now what is their problem, or even during that period, the first answer will be food, yeah? So at that time, we are also going with our messages and then campaign. To them, what matters first is they want unga in their